Hello guys, my name is Surendraj and my matrix number is 201872. Today I'm going to talk about incorporation. Okay, what is incorporation? Incorporation is a legal process used to form a corporate entity or company. A corporation is a resulting legal entity that separates the firm's assets and income from its owners and investors. Corporations can be created in nearly all countries in the world and are usually identified as such by the use of terms such as Inc. and Limited in their names. It is the process that legally declaring a corporate entity as separate from its owners. Incorporation is divided into two, which is pre-incorporation and post-incorporation. If there is a contract during pre-incorporation, the promoter will be entered into a contract on behalf of the company since there is non-existence of the company. If there is any damages for breach of contract, the promoters will be liable for the damages.
Let's see the procedures of incorporation. The first procedure is requirement for approval of company name from Suruhanjaya Syarikat Malaysia. This means that a name application must be made to ensure that the proposed name is available. If the proposed name is approved by SSM, the application to incorporate the company would be directly sent to the officer to be processed. The second procedure is lodgement of application to incorporate the company. There are some particular details required to incorporate a company. The details as follows: proposed name of the company, the status of private or public company, the proposed type of business, the address of registered office, the business address, complete detail of directors and promoters, declaration from the directors or promoters that he or she is not an undischarged bankrupt either in or outside Malaysia and has not been convicted of any offence whether in or outside Malaysia. The third procedure is incorporation fees for applicants. The fees as follows. For a company limited by shares, the incorporation fee would be Ringgit Malaysia 1000, while for a company limited by guarantee, the incorporation fee would be Ringgit Malaysia 3000. The fourth procedure is verification of incorporation if the registrar is satisfied. When registrar is satisfied that all information provided is complete and complied with the required procedures, a notice of approval and registration will be issued, and a certificate of incorporation will be issued by SSM only upon request together with the prescribed fee. The fifth procedure is once incorporated and known as post-incorporation, the company shall appoint a company secretary within 30 days after incorporation. The company secretary shall be registered with SSM and possess a valid practicing certificate issued by SSM. If required by the company, it may file the constitution of the company after the incorporation of the company. Once incorporated, the company is advised to obtain the necessary license, permit, approval from the relevant authorities before commencing business. That's all for the procedures of incorporation. I hope now the viewers has an idea about the incorporation. Let's move to the next element.
Hi everyone, I'm Sharmila Murugan. My metric number is 203380. Now I'm going to explain about the separate legal entity. Separate legal entity is an individual person recognized by law who has its own legal rights and power and has its distinct personality. That person could be a company, limited liability partnership, or any other entity recognized by law which is distinct from its member. A company is defined to be an artificial person. The doctrine of separate legal entity is a main reason why companies are being incorporated. Separate legal entity means that a company really exists and that company can sue or be sued in its own name. The company also can hold its own property and liable for the debt incurred. These concepts allow limited liability to shareholders because the debt incurred are liable by the company and not liable by the shareholders of the company. This concept was clearly illustrated in the case of Salomon versus Salomon and Company Limited.
One of the example case is Salomon versus Salomon and Company Limited. Mr. Salomon converted his prosperous business of boots and leather into a limited company named Salomon. He sold his business to company for debentures secured with floating charges on company's assets amounting to £10,000, 20,000 of shares for £1 each, and £8,782 in cash. Mr. Salomon was a managing director and two of his sons were directors. The company soon ran into difficulties and was liquidated. The creditors were started to ask for money and sued Mr. Salomon for the recovery debt. What will be the judgment? Finally, the judgment was in favor of Mr. Salomon. In this case, Mr. Salomon will not liable for the debt since the company has a separate legal entity. This is one of the advantages of a company incorporation.
My name is Divya.Kanan. My matric number is 201877. Now I'm going to talk on Constitution. A company constitution Malaysia, which previously referred to as a Memorandum and Article of Association, is a legal document recognized by the Companies Act 2016. It generally specifies the rules governing the relationship and activities of the corporate, its shareholders and directors. It sets out the objects and power of a company and also governs the internal affairs and management of the company. The Constitution has a wider and more binding legal effect than a shareholders' agreement.
Is the Constitution mandatory? Under the Companies Act 1965, every company is required to have a memorandum and articles of association. According to the Companies Act 2016, the M&A are now collectively known as the Constitution. A company may choose not to have a constitution or prepare a constitution based on its business requirements. Under the current Companies Act 2016, it is no longer mandatory for a company to have a constitution. The company are just encouraged to have the constitution for the following reasons. The constitution provides to the directors and shareholders with peace of mind as it set out a calibrated set of internal regulations to govern the management of the company, its shareholders and directors. The constitution may be amended in accordance with the wish of the company's members. The constitution provides flexibility and greater certainty to the directors and shareholders to deal with the relevant authorities, facilitate dealings with banks, and handle licensing matters with relevant parties.
Hello everyone, I'm Agale Sendithchalan with metric number 202063. What if a company does not have a constitution? The entire provision of the Company Act 2016 would then be applied to the company and would act as a default constitution. That would mean that the rights, powers, duties, and the obligations of the directors and shareholders would be governed under Company Act 2016. Now, what is the object clause? According to Section 35, Subsection 1, Company Act 2016, if a company adopts a constitution, it may contain object of the company, capacity, rights, powers or privileges of the company, matters contemplated by the Act to be included in the Constitution, and any other matters. In this case, object clause is the provision in the Constitution that states the ultimate objective of the establishment of the company. Object here refers to imply some notion of purpose or description of the nature of a company's business in a broad way.
Let's look at what are the categories of object clauses. Firstly, independent clause. Independent clause, also known as main object. It refers to the activities in which a company is specifically authorized to engage. The company must state the main objects to be pursued by the company on its incorporation. The main object required to be clearly stated by the Act in order to avoid any ambiguity. Second, dependent clause. Dependent clause refers to unspecific activities in which a company is authorized to engage in association with one of its main clause. Dependent clause cannot be entered upon the company independent of the main objects as stated in memorandum. These are such objects which, upon a fair and reasonable construction, may be regarded as incidental or conducive to the attainment of the main objects. The third category is power. Power is the legal ability by which a person may create, charge, or extinguish legal relations. The power are merely used in furtherance of the company's objects. Next, the object of a company is important for the following reasons. Firstly, to determine the nature of the company's business. Secondly, it defines what the company's powers are. Thirdly, it states the purpose for which the company exists. Lastly, to determine the legal capacity of a company.
Hello everyone, I'm Mirashini Devraju. My matric number is 201933. Which company must have an object clause? The company limited by guarantee and the company limited by shares. For the company limited by guarantee, they are required to have a constitution, whereas the company limited by shares, this company may or may not have an object clause. It depends on the company to have a constitution or not. How the breach of object clause happened? Under Section 35, Subsection 2, Company Act 2016, if the object clause included, the company cannot do any business other than stated in the object clause. Besides, when a company does any act that beyond the object clause, for instance, if the company enters into a contract that is beyond its corporate power or legal authority, such an act is called as ultra-virus act. Thus, the company is liable for the breach of duties under Section 213, Subsection 4, Company Act 2016. However, if a third party dealing with a company, it can rely on Section 21 and Section 39 and assume that the transaction is within the company capacity which the company has the full capacity and right to undertake a business or activity. There was a company and it was incorporated for carrying on a hotel business. The company had decided and entered into a contract with some third party. The contract is made for purchasing furniture, hiring servants, and maintaining omnibus. The purpose or object of the company was only to carry on her hotel business. It was not expressly mentioned in the object clause of the memorandum of the company that they can purchase furniture or hire servants. This deal was challenged and was sought from the court that this act of the directors be held as ultra vires. The court held that a company incorporated for carrying on a hotel could purchase furniture, hire servants, and maintain omnibus to take or receive the intending guests to the hotel from the railway station. This is because these are within the powers of the company, although it are not expressly mentioned in the object clause of the memorandum of the company or the statute of creating it. Thus, the act of the company is not ultra vires. The company cannot sue on an ultra vires transaction.
There are so many benefits of incorporating company, especially creating corporate identity as separate legal entity.
Separate legal entity requires a set of structure which help the company to run more efficiently.
A company constitution specifies the rules which the company needs to be operate.
Therefore, a great care should be taken by every owner of the company during the creation of company constitution as it brings benefits to every company in Malaysia.
An object clause must be included in their memorandum of association to determine purposes and power of the company which pursuant to the objectives.